All right, folks, let's come to order. I'm Judd Campbell. I'm filling in for Michael McConnell here, who's off, and really welcome you all to this constitutional law conversation with Curtis Bradley. Professor Bradley is the Alan M. Singer Distinguished Service Professor of Law at the University of Chicago. He's a leading expert on international law, foreign relations law, constitutional law, among other things, and he's going to talk today about his new book, Historical Gloss and Foreign Affairs, Constitutional Authority and Practice, hot off the presses, just released yesterday. He previously taught at Duke. He served in the State Department. He did clerkships on the U.S. Court of Appeals for the 10th Circuit and on the Supreme Court for Justice White. And as usual, our format's going to be having Professor Bradley open with some remarks, and then we'll have an audience Q&A session. So think about questions and come up to the mics on the side here afterwards. And then today, in celebration of the return of cooler weather, we're going to head outside afterwards and do a reception and book signing. Have a chance for you guys to buy Professor Bradley's new book and have it inscribed. So that's just right outside in Cooley Courtyard after the talk. Thanks so much.
Thank you, Judd. And thanks for coming, everyone, on this beautiful day. I'm going to be talking, as Professor Campbell mentioned, about a book that just came out yesterday on historical gloss and foreign affairs. And I'll talk for maybe about a half an hour or so, and I definitely would love to have questions if you have some after I've given you a preview of the book. So what I will do in a half hour is I want to just describe the general focus of the book and give you a few of the examples that come up that are from U.S. history, and then reflect on what these examples might tell us about constitutional interpretation and also the proper role of the courts. So the core question in the book is this one, which is, how is foreign affairs authority distributed in the U.S. between the Congress, that is the legislative branch, and the presidency? Always a core question today, as it was even at the founding. And the first thing you would probably do, I would do, is I would want to look at the text of the Constitution to see what it might tell us. If you do that, you would immediately run into a problem, at least in the foreign affairs area, which is that many of the questions you would have are not going to be there answered in the text. The text is silent about many key issues that we think are central to foreign affairs. Just to give you some examples, they're listed here. No mention of just recognizing foreign governments in their territories, declaring we're going to be a neutral. How do we get out of treaties? Nothing in the Constitution about how we get out of them. Big one, regulating immigration, always a topic of debate and discussion. There's actually no immigration clause in the Constitution, interestingly enough, and one can keep going, giving many more examples. Now, it might not be a big problem. Maybe the founders were quite busy in the 3 months. They were working on the constitutional text. They dealt with what they could. If we could easily change and update the Constitution, we would probably have done so in the 230 or so years, but it's extremely difficult to amend the American Constitution. In fact, it's basically the most difficult to amend Constitution in the world. It's also basically the oldest written Constitution in the world. And if you add up those two facts, basically the oldest written Constitution and just about the hardest to change Constitution, you end up with really a dilemma, which is we need to have foreign affairs powers, obviously, but the text is not going to provide a lot of guidance about that. And then, to state the obvious, we live in a hugely different world than those who wrote the text in 1787. So, what you would all know, we went from 13 former colonies on the eastern seaboard of the U.S. to the entire continent, plus Alaska and Hawaii, plus overseas possessions. All never really contemplated, much of that not contemplated at the founding. What about diplomacy? We had exactly 7 treaties when the United States started. We have tens of thousands of treaties today, also not at all contemplated. What about military power? We had about 600 people in the Army when the Constitution started, and we had exactly no Navy whatsoever. That was the military. What about today? 1.5 million people in the standing military, bases around the world, nuclear superpower, you know the story. What about just interacting with, diplomatically with embassies and the like? Well, our State Department at the founding was Thomas Jefferson and a couple of clerks. That was the State Department. They have about 77,000 people in the State Department now, embassies all over the world and consulates, etc. Many, many changes. From the perspective of our text, which has not changed in any of these regards for 230 years, we're basically conducting our foreign affairs with a horse and buggy constitution. Not at all updated, at least in a formal way. Now, if you've studied constitutional law, there's often an answer to this dilemma. You know it from other areas of law, and it's the courts. The courts in the United States have become very powerful over time and have done a lot of work in the constitutional law area to interpret this kind of laconic old document, sometimes very expansively, particularly with respect to individual rights. But this has not happened and is unlikely to happen in the foreign affairs area. The courts, for a variety of reasons, tend to stay out of foreign affairs disputes. They don't think they have the competence to address issues about our relationships with other countries. They think they would have a difficult time predicting the consequences of deciding one way or the other. And a bunch of traditional limiting doctrines that tell courts what to hear and not to hear happen to have particular bite in the foreign affairs area. Listed a few up here. Those of you who have studied some of these doctrines, like you have to have standing to sue. Well, many times private parties don't have standing to sue, and we typically don't let Congress sue when they're unhappy with the president's foreign policy. And there's also something called the political question doctrine, and it doesn't have a huge amount of life in many areas of law today, but it does in foreign affairs. If you just started reading lower court cases that had foreign affairs dimensions, you would discover the political question doctrine keeps coming up. Anytime there's a war, there's often litigation about, say, the war in Iraq. There were suits brought against Bush. They were all dismissed because of the political question doctrine, lack of standing, lack of institutional rightness. The courts tend to stay out of these disputes. What happens then is that the political branches, that is Congress and the executive branch, still have to interpret the Constitution. They still have to make decisions about allocations of authority. And they do. And some of them stick, some of them are repeated, some of them end up being bipartisan. Sometimes the president asserts authority and Congress accepts it, and vice versa. And I'll give examples both ways. Congress asserts authority and presidents go along. And over time we have a practice. And it becomes a kind of precedent. We're used to precedent of the courts. If the Supreme Court decides a case, subject obviously occasionally to overturning them, but for the most part we think those are decisions that create a kind of precedent that then guide the courts in the future. The exact same thing happens outside of the courts, which is that the president and Congress create their own precedent that in many instances end up having the same kind of force as a judicial precedent, even though we often don't talk about it that way. And that's what the book describes as historical gloss. There's kind of an analogy I'm going to give you, and I'll tell you later why gloss in particular might kind of seem like an odd word. But historical gloss is that accumulation of non-judicial precedent established by the political branches that end up filling in, informing, sometimes creating American constitutional law, at least in this area, some other areas as well, but the book focuses on foreign affairs. And the analogy is, this is like medieval scribes, literally annotating, say, the Code of Justinian or a theological text. They were called the glossiers. They glossed the text. Well, our political branches also gloss our text over time. And this is not some mere academic-y idea that I happen to think of just sitting in my office. This has been an idea that's been around since the very beginning of the country. And I just can only give you, obviously, a few examples. Very famous early Supreme Court opinion about a national bank called McCulloch versus Maryland. Chief Justice Marshall, probably the most famous Chief Justice on the Supreme Court. They hadn't been around that long. I think to them it felt like they had been around a while. 1789 to 1819 have kind of a long history already. And the practices of government, Marshall says, will help resolve doubtful questions about constitutional authority. Already saying this 30 years or so out. Fast forward, William Howard Taft, who was kind of a scholarly president and also a justice himself, reflected that in fact precedents, there's that word, from prior administrations and Congresses then provide construction of the extent and limitations of power. Nobody's here referring to judicial decisions, they're referring to other kinds of precedent. And probably the most famous Supreme Court writing that in modern times that's endorsed this approach to constitutional interpretation is Justice Felix Frankfurter in a famous case in the 50s about Truman's effort to seize the nation's steel mills during the Korean War. And there were a number of important writings in that case, but one of them was by Frankfurter, who said, it's not enough to just say there's no text supporting Truman. That it's just the beginning of the discussion, says Frankfurter. We really have to look at this practice and precedent established outside of the courts. And here's a sentence, traditional ways of conducting government cannot really supplant the Constitution, but they give meaning to it. Exactly the kind of thing we might say about judicial precedent. And you could find many other examples throughout history from the courts, from presidents, and members of Congress. I don't have that on the slide, but you could. Many members of Congress have made similar statements. Now, courts often don't weigh in on foreign affairs cases. They do occasionally, and they certainly do on some other separation of powers cases that aren't loaded with foreign affairs issues. When the courts do come in to separation of powers disputes between Congress and the executive, maybe between the House and the Senate, they themselves have said that gloss, or historical precedent, is in fact important to their decision-making. And I'll give you some examples in a second, but here are the reasons why they tend to look to it. One is they don't have a lot of their own precedent, let's be clear, often, and therefore they need something, but it also allows them, in effect, to do some updating from this 230-year-old Constitution. It reflects a kind of deference. The courts have said they understand that if the Congress and the President have worked something out for a long time, they should not lightly just overturn it. That they probably are not in a better position to know how the practices of government ought to work than the government actors themselves. I would say, those of you know a little bit about Edmund Burke and his approach to kind of taking things gradually in constitutional change, there's very much an element of that, there's a caution. Let's not radically overturn things that seem settled. We don't know the consequences of doing that. So just a few examples. I could have given you many more. These are not foreign affairs ones, because I'm saving those for a couple of minutes, but the scope of the veto power, it's not clearly articulated in the text of the president's ability to veto and pocket vetoes. Well, when the Supreme Court got it, they immediately said long settled practices matter of great weight in figuring this out. Pretty recent decision about the recess appointments that presidents make when the Senate's out of session, fill in, at least temporarily, offices that have become vacant. The Supreme Court went on at length, by the way, that said practice is very important to deciding those kinds of questions. They didn't have a lot of cases, so they just started going through all the presidential practices, and they made the decision accordingly. More recent than that, what's executive privilege? It's not written in the Constitution. Presidents have always claimed some amount of privilege from having to turn things over to the legislative branch. When the Supreme Court got it, they haven't had a lot of cases in there. They said we have to give great weight to how this has worked and how Congress has demanded things, how presidents have responded over time. So let me shift over to foreign affairs and show you why it's particularly salient there. I'll just give you 3 examples from the book. There are more in the book, but these are 3 that I think are especially important. One is the rise of something called executive agreements, and I'll explain what those are, but they are a huge part of our diplomatic practice today. They weren't at the founding, so that's a change. How do we get out of treaties? I mentioned there's nothing in the text of the Constitution about how the United States actually ever gets out of a treaty. You would think somebody would have written that down. They didn't. Use of military force is probably the most contested example I'll talk about today. Everybody always fights about this example, and there's been a lot of changes, and presidents, I think you probably know, exercise a lot of authority in ordering the troops to get involved in hostilities. Okay. Maybe the less controversial one to begin with, executive agreements. This chart may tell you a lot. So first of all, what are they? The Constitution says only one thing about how the government's to make treaties. It says the president has to get 2/3 of the Senate to agree, 2/3. Now, if you know anything about politics today, but even to some extent about the founding, 2/3 is going to be very difficult to get because you have to get a lot of votes from the other party. Nowadays, it's basically impossible, but it was often impossible throughout various periods of contested partisanship in the United States to get 2/3 really hard. And it was, I think, done on purpose to make it hard to make treaties. When the United States began, the thought was treaties would pull us into bad things and entanglements. That's what they said. So make them rare. Well, by the time we get involved in the United Nations, we're making thousands of treaties. The United States is a superpower. It wants to make treaties. It wants to make agreements and cooperation all around the world. Not a constitution that's really well designed for it, because the world's changed too much. So for a long time, presidents have made other arrangements for agreements by not going to 2/3 of the Senate. And whenever they don't go to 2/3 of the Senate, we call it an executive agreement. Now, if you ask anybody outside the US, what are those things? They would say they're treaties. What do you mean executive agreements? What does that even mean? We only use that term in the US because we have to give a different label to the ones that we still occasionally take to the Senate. Well, I say occasionally. Early in history, okay, treaties were the dominant form. We would make big treaties with the British and the French, et cetera. Occasionally, these other things, not going to the Senate, but not a big deal. Look to the 50-year period from 39 to 89. Okay, we're still making treaties, 700, 11,000 executive agreements. More than 90% of the international treaties the United States makes today are not going through the only clause in the Constitution that talks about making treaties. Complete change in our practice. Why? Part of it is just too hard, and we have too many. The Senate couldn't even process all these, even if it wanted to, which it does not. So what do we do with the fact our practice has changed so much, and there's nothing in the text of the Constitution about executive agreements? Well, the bottom line is the Supreme Court occasionally has gotten these when there's been some dispute that there's actually standing for somebody to sue. And every time they say, we're not going to throw this out. This has been exercised since the early days of the Republic. That's a case called Garamendi about settling some Holocaust claims. Iran hostage crisis. Carter settled it through an executive agreement, didn't go to Congress or the Senate. And the Supreme Court, maybe not surprisingly, says, there's a long-standing practice. And it looks like, in fact, Congress has kind of acquiesced, at least in this area, to let the president have this leeway. It's not for us to overturn it as unconstitutional. And this will surprise no one. The executive branch always loves this argument as well, probably in all areas, which is if we've got long-standing practice by the executive and legislative branches, it's a practical construction to the Constitution. And of course, they thought. This was, I think, as a memo defending the GATT trade agreement, huge. Set up the World Trade Organization, big deal. Not done as an Article II treaty, done as an executive agreement. Executive branch says it's constitutional, and the court stayed out of that. There were some disputes about that. The court stayed out. So the courts, the executive, and I would say Congress, since Congress is also blessing a bunch of these things, it's just not through the Senate, have all kind of acquiesced in the story that executive agreements are constitutional because of the practice, even if maybe in 1790 they would not have been. A clear change. Another example, how do we get out of treaties? We only had 7 at the founding, so I just don't think they were heavily thinking about it. Now, we had to get out of them quickly, it turned out. 2 of the treaties the United States had were with France. It wasn't long before the United States was going to war with France. So we did pull out of some treaties, actually within 15 years or so of the Constitution, but I don't know that they were thinking that might happen. For whatever reason, it's not written down. And the practice is really interesting because it's changed even around separation of power. So I've looked at all the terminations in history. How many have there been? Maybe several hundred. That's not a lot throughout American history, terminating treaties. And maybe there were 70 or so in the 19th century. Presidents, for those, generally went to Congress or occasionally to the Senate. And they said, would you give me permission? I want to pull this out. It's not a good deal for us anymore. I'd like to get us out of it. Or the British are breaching it. I'd like to get us out. And Congress usually gave them permission. 20th century happens. We start having more treaties, by the way, and therefore more you might want to pull out of. And also Congress is also passing all sorts of protectionist trade legislation. Can't imagine that happening again, but it did. And that caused conflicts with treaties. And as a result, there were more we needed to pull out of. And presidents, instead of just going each time and asking permission, just started doing it. And mainly Congress didn't object. Many of them were just to resolve conflicts Congress had created anyway. And Congress, these are low-level things Congress didn't care about. By the time we get to FDR, now, he's a very popular president, so popular he actually gets elected 4 times. So he has a long history for one administration. And he's now unilaterally doing a lot of things in foreign affairs, including he just pulls out of treaties when he thinks we need to. Congress not really complaining. And Congress basically doesn't complain about this shift to presidential unilateralism until they have a big policy disagreement in the 1970s, which is when President Carter decides to recognize mainland China, and as part of that, pull the US out of a defense treaty with Taiwan without going to the Senate, without going to Congress. Now, many people in Congress think the whole idea of recognizing the PRC is a problem, and certainly they don't like pulling back from the defense of Taiwan. So they actually sue President Carter in courts, saying, you don't have the authority, that treaty was made with the Senate's advice and consent, how dare you act on your own. That goes up to the Supreme Court, Goldwater versus Carter. Supreme Court, now it was splintered decisions, but the Supreme Court says, sorry, not a justiciable case, we're not going to tell you the answer. So that was the end of that. We do pull out of the treaty. Carter wins by lack of judicial decision. But since then, so controversy in the 70s, but if you look at, it's hard for me to recognize. I remember these events, but that was 50 years ago. And presidents since then have basically terminated maybe 40 or so treaties, all basically on their own, almost never with controversy from the legislative branch, and no more. And to the extent anybody tried to sue, all the cases have been tossed out. So the practice now, not in the 19th century, but the practice now is that presidents terminate for the United States. And by and large, except when there's an occasional policy disagreement, Congress doesn't seem to complain too much. Again, the executive branch, not a surprise. It's a recent memo. Says we've got plenty of history here to claim that this is a power. And they actually confess, partly because I had outlined it, I think, in some writings. They said, you know what, it may be different in the 19th century, but thankfully we're not in the 19th century. Now we have this authority. Look at all the modern practice. This is also, by the way, the views of the new Restatement of Foreign Relations, according to established practice. Now, I did draft that, but nonetheless, it is in the Restatement. And that's a position that I had to persuade other people about as well. And so the scholarly community, to some extent, came around to the same conclusion. But again, not because of the founding, not because of the text, not because there was some fixation of power at the beginning, but because of some adaptation from historical precedent. Reasonably uncontroversial. There are people who accept what that slide says but don't love it. They wish it weren't so. They don't like pulling out of treaties. President Trump pulled out of a lot of treaties. People didn't like that. But there's kind of a grudging acceptance, I suppose, of this. Now, the hardest example is military force. And if people who study in this area, this would be what would get people most exercised, the changes in this area. Now, the Constitution has things to say. That's part of why people get exercised. It's not as if it's silent like treaty termination. It says Congress has the power to declare war. Okay, that sounds like Congress. The problem is you immediately run into difficulties, which is most wars, even in 1780s, were not declared. So how does that work? What if you don't declare war? Do you still have a war? Also, the president's the commander-in-chief under the Constitution. What does that mean? It's not defined in the constitutional text. What if the United States is attacked? Can the president defend? It was always assumed the answer was yes, by the way, from the very beginning. But it's not in the text of the Constitution, defense of war powers. Very complicated history. So in the 19th century, presidents were kind of timid about their war powers compared to the modern presidents we have now. But over time, they often authorized, particularly the Navy, to engage in small-scale uses of force abroad. Not major ground invasions or anything like that, not major wars with European powers, but smaller-scale uses of force, occasionally controversial. Congress. Now, keep in mind the world that was. Communication was super slow, so Congress would sometimes find out about some bombardment 8 months later and then have some hearings maybe 6 months after that. And so the president would go and say, yeah, a year and a half ago there was a bombardment, and it was often a little bit late to have a lot of checks and balances. And the big wars of the late 1700s and throughout the 19th century were all, I'll give you that slide in a minute, but all authorized and even declared, for the most part, except for the one with the French, by Congress. So largely, for big wars, certainly, Congress was the key authorizer. But you can tell the uncertainty creeping in the early days. I love this quote from John Quincy Adams. He's giving a eulogy for James Madison, architect of the Constitution. And back then, when they were giving eulogies, they'd give you a whole lecture about all sorts of things. This one's partly about war powers. And he says, we're way out now. Look at all our 50 years out from the Constitution. Think about all our practice. You wouldn't think that this commander-in-chief would get to start wars, but it's got to be the case that they do have the power. Why? They've done it to some extent in a low-level way for 50 years. They must have the power. This is Adams commenting on kind of a remarkable fact. And we have now 230 years, not 50, to think about. And I would say one of the shifts, not everybody knows this part of U.S. history, was 1900. So the United States has had the Spanish-American War, which was declared, and Congress was involved. Now we have a bunch of troops overseas in the Philippines. So now there's a big uprising in China, where maybe American lives are at risk, et cetera. McKinley just sends over 5,000 troops on his own authority into China to fight. No Congress getting involved. And not hugely controversial. I think Congress applauded from the sidelines. And those of you who may know this history as well, in the early 1900s, you get Teddy Roosevelt and others using the US Navy and the military in Latin America a lot to quell uprisings, protect creditors' interests, dollar diplomacy, keep the Europeans out. And they often call these police actions, as if the US were the police force for Latin America. And Congress was not authorizing that, but often didn't object. The two world wars come along. Of course, Congress very much is involved. They declare World War I, World War II. The last time they ever declare war was during World War II. That's it, 1940s. And then Korea comes along after World War II, 1950, and President Truman decides not to go to Congress. He's advised by the Secretary of State, don't create a bad precedent of going to the legislative branch. And he just responds to the crisis in Korea and sends what ends up being a very large commitment of troops for several years, huge numbers of casualties as well. And that entire war never expressly authorized by Congress. By the way, just like in Latin America, he loves that phrase, we're going to call Korea a police action as well, this time policing for the UN. And it happens. It was controversial to some extent, but not at first. Congress didn't object at first. Only when the war was going badly did Congress start to say, why didn't you ask for our permission? What do the modern practice look like? You read about it in the papers all the time. Some of the big conflicts, Vietnam, it did have a statute, even though there's some debates about that. The two Iraq wars, Afghanistan, you can say the war on terror as well, all have statutes. No more declarations, but they have statutes where Congress authorizes these conflicts. But many short-term, smaller aerial bombardments, even short-term invasions of Panama and Grenada, not authorized by the legislative branch. Presidents just do it. Now, Congress, at the end of the Nixon administration, got uptight to some extent about all of that unilateralism and passed a statute. It's still with us. It says if you're doing this after 60 days, you've got to come and get permission. You've got to stop or get permission. What has happened? Presidents have worked around it. Sometimes they've kind of disregarded it, I think, but they never say they're doing that. They sometimes just make the Panama or Grenada invasion shorter than 60 days. Say we didn't violate the law. They sometimes say, well, you just gave us some appropriations, which Congress almost always does. Once they're doing a long-term campaign, Congress gives more money, and then the executive says, well, you just gave us more money, you must be authorizing it, even though Congress doesn't say that. So they find more ways. Now, the most dramatic, 2011, Obama's lawyers said, this only applies if we're in hostilities. We're only bombing in Libya. They're not really bombing us back, so that's not hostilities. So we don't have to worry about the statute. That was a little bit of a crazy argument, and I won't even say which academic made it, but it was made by a law professor who was working in the administration at the time. The executive branch, not surprising again, draws on practice to say even if George Washington couldn't do these things, even if John Adams couldn't do these things. We can now because of long continued practice. Acquiesced in by Congress, that's a debate, of course. And what they say is at least if it's not such a big conflict that it would arise to the level of a war, the practice seems to give us the authority to act. There's a debate about that, and I'm happy to talk about it in Q&A. That's sort of where the practice looks like now, and I would guess will look like years from now. I don't think that's going to change, and courts have done nothing to weigh in. They go out of their way not to hear war powers cases. Before I finish, though, I do want to say, because that's a lot of pro-executive development, is that Congress also cites historical practice a lot for its own powers. It's easy to forget because the executive gets a lot out in foreign affairs. But a lot of things we call congressional power, including like immigration and passport control, even things in war like treatment of POWs, Congress regulates all these things. And it's not all clear where they get the power to do some of that. And a few times the courts have gotten involved and said, well, they've done it a lot, so they probably have the power. And the executive hasn't really fought them on that. They get some gloss as well. Maybe even more importantly, there are just some things because of practice we don't let presidents do by themselves. They do start using military force at times, but it is settled. They can't extradite criminal suspects. Why? Because Congress or the treaty power has always been engaged, a lot of practice. You would guess about trade, given Congress's powers in that area, but we don't let presidents just start using trade restrictions. Immigration, not clear who that was supposed to go to, but Congress has regulated it since the 1870s, and the courts have said basically the president has to draw their actions from statutes. And of course, money is still very much a practice that goes to the legislative branch. But I would say the most important thing about that is not even that some things are off limits. It's that practice only tends to support the president having power to act, not a preclusion of Congress. Most of the topics in the book, including executive agreements and pulling out of treaties and starting conflicts, can all, and in fact are sometimes regulated by the legislature. And practice does not suggest presidents should be able to ignore legislative restrictions. If it did, we'd have a huge problem. And Jackson, another opinion from Youngstown, which is famous, basically said you should be very wary about saying the president can disregard statutes because we really don't have checks and balances. And practice does not show that. Congress has been involved in all of the topics in the book at one time or another. Now, what have they done a lot of? They've regulated and then delegated back to the president, a lot. If you think of all the sanctions Biden imposes because of the Russian invasion of Ukraine, it's all statutory delegations. And people complain maybe that they've given way too much to the president and too much discretion, and you hear about some justices maybe thinking about a restriction on delegation. I doubt they're going to do it in foreign affairs. But that's not a gloss problem. That's Congress maybe giving away too much of its own authority. And again, if Congress wants to act, the story of our practice is that they usually can have the last word. This really matters, by the way. I want to give you an actual concrete example from this last year, and I hope it's a hypothetical. I really do. Congress has said last year, no president can pull us out of NATO without going to Congress or the Senate. It's a statute. It was Biden didn't, by the way, presidents issue all these signing statements. I looked for this one. Biden had a bunch of signing statements to other parts of this big bill, quiet as can be as to this section, even though it intruded on executive authority. I can't imagine why. So Biden's non-objection will be a factor, probably, if people have to figure out whether this is constitutional. I think it is, by the way, and I defend stuff like this in the book. But oh well, and I part company with the Office of Legal Counsel in the Justice Department, which said in the Trump administration concerning a different treaty that, in fact, this is not only a practice of the president to pull us out of treaties, but one that can never be limited by Congress. It doesn't make any sense to me, since all of our terminations were done through Congress for the first 100 years. And they kind of quietly just forget that practice, in my opinion. But this could really matter, and there are lots of examples like that. Let me finish, and this may anticipate a few questions. I think this is maybe the most important part of constitutional reasoning in foreign affairs for the last 230 years. It's much more dominant than originalism or textualism or other free common law constitutionalism. All the big theories of constitutional law were taught, not almost ever a major form of constitutional reasoning in foreign affairs. Historical gloss has been the dominant one from day one, practically, in the first Congress, all the way up to today. But there are objections, and I get it. One is, and I'm going to end on this concern, which is just too helpful. Even with the things that Congress gets a little bit, it's too helpful to the imperial presidency. We're not really seeing acquiescence. I think that's probably true sometimes. Being quiet is not acquiescent, it's just quiet. We're letting the Constitution change on some things. Should we do that? Well, I would say these are long-standing practices, bipartisan, stable for the most part, and we get a lot of constitutional change from 9 justices who happen to just get a majority. And this maybe looks pretty good as a comparison. It's often you can have disputes about how to describe the generality of practice, but I think that's true of all precedent. I'm not sure that's unique. And the key question is whether you can think of a better alternative. If you want to just say originalism, we're only going to have a constitution that exactly is the one you would decide in the day after 1789, you've got to be ready for the thousands of problems that will create. Let's also throw out 20,000 treaties while we're at it. Probably not going to happen. This is what bothers people the most. This is the number one objection when I workshop the papers that led to this book, which is, I feel like the president's too powerful. And this just gives, we saw all those OLC slides, gives them another argument to try to win over Congress and do things without getting permission. But what I want us to think about is what's the baseline? How do you know the executive is too powerful, by the way? How do we know President Biden is too powerful in foreign affairs? And by the way, when I use the Biden example, people say, oh, no, that's okay. I want him to have a lot of flexibility with that Ukraine problem. I don't want him to be tied down. In fact, the Congress is usually the problem there. But Trump, he had way too much power, recognizing Israeli sovereignty here and doing all sorts of things. I don't like that. But what about Obama? Obama was all right. And it depends on the presidency at this point. But you can't have a theory that turns on whether which president's in office. And I think most of them are, by the way. And most of the people who object aren't originalists, the people I talk to. They're not saying it's just a rule of law thing. You can't have a constitution that looks different today than 1789. They don't say that about anything else in their lives. So are they saying that here? I don't know. And I don't even want a president that's as weak as George Washington. And by the way, George Washington knew most of it was unsettled. Every day in his diary, Washington said, I think I'm setting a new non-judicial precedent. Like, he knew. He was fleshing out the Constitution. So we don't know what and by the way, the biggest contributor, if you had to pick one president, is FDR. And many people think he was great. Maybe one of our very best presidents. So it may be that some initiative power of the president, with, importantly, the ability of Congress to respond, may be the best scenario, or at least an adequate scenario, which is basically our law today. And by the way, Congress have now accumulated so many statutes. If you can think of a topic in foreign affairs, I'm guaranteed there's some statutes somewhere there. Congress they just delegate a lot. It's not because they're out of the picture altogether. I wanted to address that concern. So the key question is whether there's a better alternative. By the way, the Supreme Court, I'll note, I just picked some things from the last term, very obsessed about this topic. Good timing for me. They're really worried about this because they have all these other cases about history that aren't really foreign affairs. So they're getting this financial services thing about appropriations. And 4 justices say, we just want to write separately to talk about history being really important. Didn't really have to. They just thought that they knew that all these debates were happening. Kavanaugh writes separately in the gun rights case just to say, I want to talk about methodology. And he cites a bunch of law stuff and other history and tradition stuff. And he says, as I've been saying, that these post-ratification interpretations, if they're consistent and longstanding, can be probative. And he wanted a conversation about that. And I think they ought to have a conversation. Finally, takeaways. As may be evident, I think we focus way too much on the courts. I have, teaching constitutional law and reading about it. I think we focus every term on the Supreme Court. They decide 50 or 60 cases, many of which are not even that momentous. Most of our constitutional law in the United States is not done in the Supreme Court. Almost none of the foreign affairs constitutional law is ever done in the Supreme Court, but it's there. And we focus way too much on just that court. And I would say there are some lessons here about maybe the courts not over-deciding, letting the political branches probably have some space to bargain and interact, because otherwise they could distort a lot of the practice. And I think they know that. That's why they tend to stay out. And very importantly, don't give pockets of exclusive authority very lightly at all, because that will just shut everything down. And when they've done that, they have done it once recently in the foreign affairs area. I think it was a mistake. And I will end with this, and I'd be happy to take your questions, which is, this is back to Justice Frankfurter, uses the word gloss, as you can see. It's an inadmissibly narrow conception of American constitutional law to confine it to the words of the Constitution, and to disregard the gloss which life has written upon them. That, if I had to say there's one lesson of the book, it's really that quote from Frankfurter, and I hope readers will take that away. So I've enjoyed talking about this project, and I'd very much like to hear your questions and talk with you about them. Thank you. All right, questions? I bet there are some. Oh, you got some, good.
Hi, Professor. Thank you so much for coming for
My
this
pleasure.
excellent lecture.
Thanks.
I take your point. It's very persuasive that there are very few possible sources of foreign affairs constitutional law. One alternative might be British practice before the founding. And so Justice Scalia, for example, in Boumediene, discusses the extraterritoriality of habeas and applies it to Guantanamo and says, oh, the king couldn't do a writ of habeas to Scotland. And so I guess I'm wondering, why would British practice before the founding be a particularly bad source for foreign affairs constitutional law or a particularly good source?
Yeah, good question. And there are writers who really love to appeal to the British practice, mainly because it has the British royal prerogative. And that is a lot of foreign affairs power. The problem is that the founders went out of their way to say we don't want a King George even in foreign affairs. And so they already right off the bat split a bunch of prerogatives over to the legislative branch. They completely disrupted the British scheme. And then it's just, so you might say treaty termination, the British king could have done it. Now, interestingly though, treaties in the UK never have domestic law status. Parliament has to implement every treaty. We decided not to go with that either. All treaties are supreme law of the land. So every big choice is actually a departure from the British model. There are some very pro-executive scholars who said, but let's take everything that they didn't take away from the British model and push it into the first sentence of Article 2 of the Constitution, which just says the executive power shall be vested in the president. There are certain originalist scholars, and I wouldn't say a huge number, who say that's the British practice unless you see it gone somewhere else. Interestingly, even presidents haven't pushed that nearly as much as this, how you would think that they would. And only one justice on the Supreme Court has tried to go with that British move. It's Justice Thomas. And he's the one who's argued in a number of cases. Everything unclear just pushes through the royal prerogative. But I think that's so inconsistent with the founding debate. If you just go through the debates, they go out of their way to say we're not doing anything like that. And interestingly, anti-federalists never suspect that they are. Anti-federalists were super suspicious of everything, but they never thought that was happening. I wrote a whole article about whether could we think the British move was coming in. It would be 10,000s of pages where nobody seemed to realize it. Now, there was another person in our history who did make that argument, and he was very pro-British, and his name was Alexander Hamilton. So a few years after the Constitution, he's famously said, all these royal prerogatives, unless they've been expressly sent away, should come in. Madison said, you're crazy, let's not do that. So there is a strain of thought. It's interesting, it has never taken off in the way that this more kind of accretion of practice story has. But it's a good place to look, I agree, and that's part of the debates. Other questions about any of these examples or, Judd?
Great, thanks. So I'm curious about the relationship between gloss as a concept and other similar concepts that we talk about in constitutional law. So you mentioned Rahimi, and the justices are very much emphasizing tradition in that context, including a lot of state ordinary law and things like that.
Yes.
And then also your colleague has talked a lot about liquidation as a concept. I'm curious both in terms of the boundaries of the concept and then also just what it is that differentiates what you're talking about from liquidation.
Two very good questions. I'm going to start with the second one first because I have written more about the second one. So you may have heard, has anybody heard the word liquidation before? And the reason you might have heard of it, other than my colleague at Chicago having written about it, is that James Madison, after the Constitution, did mention it a couple of times, like in some letters. And what he was basically saying was, we couldn't have written everything down. A lot of it was just a framework. We have to liquidate and thereby fix some of the vague meaning through our practice. So that sounds kind of similar, and it is kind of similar. And in the recess appointments clause, the Supreme Court actually thinks they're exactly the same. They just say, we liquidate, we do gloss, it's the same exact concept, and it could be the same concept. It depends on, but no, Madison was not trying to write a treatise about this. He just said it a couple times in letters. That's all we have from him. And so what does it mean? One narrow version is that the earliest generation of Americans got to settle the meaning when it was vague through their initial practices, the first couple of Congresses. But there's something normatively problematic. Why did they get to settle it for 230 years? They don't have any supermajoritarian mandate. By the way, they were getting just as political as anybody. Why? And they weren't seeing all the thousands of new events that they couldn't anticipate to test it out. We have much more experience in Burkean wisdom than they would ever have. We're much better deciders, by the way, than the first two Congresses about these issues. So why would, and Madison never said he was doing this, but one very narrow version is you can only just fix it in the very beginning and then you're done and you can never change it. It's not lining up with anything I said, so glosses would be broader than that. I don't know what Madison thought or what and my colleague Will Bode, I think, has a much broader view that almost is basically the same as gloss, which is it could happen later, and it could even liquidate over time, or regloss. I'm not sure there's that much daylight between those two concepts. I don't mind them being the same, if in fact they are. Will just imposes in his article, that there also has to be some big public acceptance of it. That doesn't work very well in foreign affairs. Most people have no idea what's going on in foreign affairs. So the idea there's been some big public acceptance probably doesn't work as a test here. So I don't think Will was focusing on foreign affairs. Now, the history and tradition and all the other types of history that Professor Campbell mentioned about, I go out of my way in the book, partly for tactical reasons and other reasons, to say I'm not doing any of that. That is, you don't have to like the Second Amendment cases and others to like this. And here's one of many reasons. I am quite skeptical of letting, say, majoritarian practices and tradition be our lodestar for rights. We all know that majoritarian communities have often been hugely regressive about rights understandings. That's been a problem throughout American history. We think overall, at times, we're getting better. But the idea that they got to decide race rights, gender rights, just because of traditions, doesn't seem to make any. In fact, the purpose of rights is partly to check majorities. So the whole structure of why we have rights seems to get distorted by putting too much weight on the ways of doing things. And so I certainly bracket the rights element, and where I think that's less of a problem for separation of powers, where mainly it's impacting allocations across government actors who themselves have lots of power, whereas a lot of individuals do not have power in their relationships with the government. So I largely am bracketing those kinds of projects. When Kavanaugh wrote Nohemy, he just cited all the history stuff from the last 20 years, my articles, Will Bode's articles, history and tradition articles, Sharif Girgis, all in one big soup. Said, there's all this history stuff, and maybe it's different, and maybe it's not. So probably another paper I'm going to write because of this is why we should think differently in the separation of powers, a structural area about tradition and history, than in the rights area, where I think it's much more fraught, and there are other problems with it too, but that's a couple of thoughts that I have about that. Yeah. No, please.
Professor, thanks for coming and giving
Sure.
this lecture to us. I just had a quick question on your thoughts on whether FISA courts reflect gloss or not. On the one hand, I'm inclined to think, they don't, in that we have a court that actively reviews almost several thousands, hundreds, whatever the number of collection requests classified. But also given how clearly they just, approve a lot of them, most all of them, kind of reflects gloss at the same time. So where do they fall under for that?
Yeah. So FISA courts are these surveillance courts which approve warrants, sometimes in a mass way, and they're authorized by statute. So one of the pieces of practice here probably is, unlike some of what I've talked about, is more of legislative practice, which is, of course, Congress was given broad power to regulate the courts, and so should it turn off due process? No. Should it turn off the Fourth Amendment? Definitely not, for some of the reasons I just said about the rights area. But if the questions are, can you have different procedures? Can you use somewhat different courts? Sometimes that's also come up in a lot of other areas of judicial practice. Practice would be relevant to some of those if it's just a structural question. But if it's a question of whether you have Fourth Amendment rights, for example, the fact that Congress decides we'd rather you not have so much, I think doesn't really answer this kind of question, from my perspective at least. And gloss can gloss judicial power. It's not really in my book, but I've written about it separately. So lots of the structures of the federal judiciary are partly informed by longstanding arrangements that Congress has made, but I think not like the Fourth Amendment, which is really where FISA would get into. But if it's an allocation question, like can Congress delegate surveillance authority, that I think would be a gloss story. if it's a question of delegation. And speaking of delegation, some of you probably know there are some justices on the court who say they'd like to rein in delegations, because much of foreign affairs law, by the way, is delegations from Congress, including surveillance, espionage, and everything else. Every time they say it, Gorsuch or somebody, they drop a footnote. By the way, not foreign affairs, not foreign affairs. They don't want to go there. They don't want to suggest that Congress can't give lots of surveillance or other authority to the executive branch, so I don't think they're going to, I'm not even sure they're going to do it domestically, by the way. They've done their major questions doctrine, also probably footnote, not foreign affairs. There are huge major question delegations in foreign affairs. I don't see any appetite on the Supreme Court. Partly, we've had major question delegations from the embargo statutes of the 1790s on. So the idea that that's always been unconstitutional, not likely. And I think the Supreme Court, even the court that's worried about delegations, probably will give weight to that practice. Good question. Yes?
Hi. So I had a question about how much your theory about gloss you would apply to other contexts besides foreign affairs.
Yeah.
So is that the distinction, or is it more along the lines of what you were just referring to, which is distinguishing separation of powers questions from rights?
Yes.
And then what about those foreign affairs questions, which do involve questions of individual?
Yeah. Fair enough.
You mentioned FISA, but outside that area.
Yes. The distinction for me is structure versus other kinds of constitutional questions. It turns out foreign affairs is unique not because it's the only place with structural questions. So I gave you the slide with recess appointments, the pocket veto. Those are not foreign affairs cases, but they're structural cases. And so there are others, and there are in foreign affairs. The key difference, if you want to just, why would you focus on foreign affairs, is judicial review has been particularly light there. So one of the things about gloss, it only builds up long-standing patterns of practice and behavior, usually if the courts are not very active. Because once the courts have an active portfolio, everybody just coordinates. This is the United States system. We coordinate around judicial decisions. And the practice no longer operates kind of the free form that it had. Foreign affairs, it's kind of the constitutional law that never changed. So that probably was true about a lot of our constitutional law in the early days. It operated without a lot of judicial review. Judicial review takes over large chunks of American law. It never takes this over. So foreign affairs really does look different if you look at it kind of as a grouping. But not with respect to foreign affairs issues that run into rights or anything, and many do, of course. And in fact, the Supreme Court has gone out of its way to say no. Even though all those slides, they were given all this weight to practice, not when it comes to Boumediene, for example, the habeas case involving the war on terror detainees at Guantanamo. All sorts of other cases I could give as well. The Youngstown case itself, of course, is the Korean War, and it's a private property rights case, but the court does not all of a sudden say we're going to let property rights be disturbed. So I think it's structure and foreign affairs being different because it's been kind of more unaffected by judicial review. If you have lots of judicial review, we're going to just study the Supreme Court. And if you have these non-structural issues, I think the courts, when they come into them, are not going to be as deferential to the fact that majorities are happy to, particularly when it's affecting people who might not be majorities. I think they're properly skeptical, and that could be in foreign affairs as well. So that's a good clarification question. Other questions? What do you think about the NATO Act? Constitutional? I don't want to get it tested out. You think it's not constitutional? That's what OLC says. What about war powers? I always get a lot of people concerned. Even if the president should have a lot of flexibility, should the president be able to just bomb Iran or something like that? Yeah, what do you think?
That was actually my question.
Yeah.
If the presidents actually have this precedent where they just go on and other people.
Say that again.
If the president issues executive powers to go on and do drones on other people,
Yeah.
they don't have any past presidents, and they can't be internationally held liable for signing agreements.
Yeah.
Not process. How can we stop this bad practice of presidents just using their executive to do this policy with Obama and Trump?
Yeah, good. Let's suppose you hate the drone practice or the kind of intervention in certain parts of the world, Middle East or other, in certain kinds of ways. And you're right, international law, I teach that area, doesn't look that constraining when it comes to the United States. We're not really a part of the International Criminal Court. We're not going to allow jurisdiction in other tribunals that would try to limit it. We have signed the relevant treaties, by the way, but who's there to enforce it? That's always the question, obviously. Now, one observation before I answer that specifically. The worst, in terms of foreign policy problem, wars since Korea, and that's quite a long time ago now, the worst ones were authorized by Congress. not defending the other ones. But the Vietnam War, people say maybe was the worst modern war we've had. It was authorized, and then over and over. The draft was authorized by Congress. The appropriations were every year authorized by Congress. And the Gulf of Tonkin, whatever you think, was authorized and not repealed until the 70s. And people think it was a fiasco to have the war in Iraq in 2003, trillions of dollars of costs, casualties, didn't really maybe serve U.S. interests, whatever you think. Authorized by Congress, and Hillary Clinton and a lot of people voted in support of the war. So for some of the big mistakes, they're not actually just presidential unilateralism. I want to point that out. So saying Congress has to authorize may not actually solve some of our problems. Okay? But what about the lower level, the aerial bombardments, the drones? First of all, Congress is, whether you like it or not, is actually quite supportive. Obama went to Congress, maybe some of you remember this, and said, you know what, I've got this long conflict. I want to go against the Islamic State. Could you write me a statute and tie my hands a little bit? Tell me I can't use ground troops. Happy to put that in. Congress said, no, no, no. You go ahead. Congress just stood by. Why? They were perfectly supportive anyway, and there were some fights about they didn't really want restraints. They didn't want to take responsibility for that. So the argument that you have to go to Congress didn't solve some of that particular problem. Could we write a better war power statute? Absolutely. I would love it if Congress put more definitions and more constraints, and it might have some of that. But keep in mind, Congress is often more hawkish than the president. So it is a dilemma if you think we're making a big mistake. Fortunately, I think presidents, for the most part, and actually maybe one of Trump's virtues in foreign policy was he hated foreign wars. And of course, Biden finally, using the Trump agreement, pulled us out of Afghanistan. So I'm not sure there's a huge appetite. If you have to go to, final thing about that, which people forget about. If you have to go to Congress every time, you're probably not going to get less of these force uses that you don't like. You will get one major kind of force used less often. Any humanitarian uses of force are gone. We're not going to help in Somalia. We're not going to try to stop the Rwandan genocide. We didn't anyway. Congress is never going to approve that stuff. And when we had a few casualties in Somalia, ended the entire conflict. Congress just stepped in. Very rarely ever step in. They did win American casualties in a war that's only humanitarian. Congress is not some savior for these kinds of issues. And so I don't have a great solution to that if you think we're making lots of big mistakes. I actually think the bigger mistakes are these very protracted wars that don't make sense, and Congress gets all hawkish and pushes, and then the president, having all of that authority, is much more willing to take big chances because Congress is backing the president up. I actually think it's a bigger problem. It's just my own view. But it's a fair question. Yes.
Hi. I saw an article talking about the House Committee on the Modernization of Congress, and one of the proposals they had was developing a congressional equivalent to what the executive branch has for the OLC.
Yeah.
I'm just curious as to what you think this
Great question.
proposal and other proposals, if that would have any material impact on the development of gloss.
Yeah, great question. Everybody, whenever you show people all these OLC opinions, that one of the first questions is this question. It's a good one, because OLC is always kind of aggressive in favor of their client, the president. They always kind of push the practice. You know, I had to critique a number of their claims in the book because they're very aggressive. And they don't really have a good interlocutor in response. And then the courts stay out. So who's answering OLC? A lot of people think it would be great. The problem is, I hope it happens, by the way. But here's why. Why hasn't it happened already? This has been a decades-long problem. And the problem is, if you think about it, Congress has two parties who hate each other and do not agree. So one party always loves presidential power, pretty much, and the other one hates it. And the idea that they have a consistent line on that they could agree on to have represent them in a continuing basis, it just makes it much, whereas the executive always has one interest, have maximum flexibility. So whoever comes in as president likes that, and their lawyers support it. It's just so much harder with a two-party Congress, particularly a hugely partisan Congress. By the way, decades ago, Biden and Helms were doing some stuff together that was pushing back against presidents on some of these topics. I would never see that again today. So this is, how do you get an OLC in a two-party, collective action-ridden Congress that doesn't have a long-term set of interests in the way that the executive branch does? And at least that's what we haven't had so far. So right now, academics are basically trying to do the Congress OLC part. I'm trying to do it. I'm pushing back against some of the OLC opinions, but it'd be better if there was an institutional voice. I agree with you. Yeah. Yes?
Hi. Thanks for this. I guess I'm curious, you had a few cites in there to OLC memos from 2018, from 2021.
Yep.
when we talk about kind of presidential authority in the foreign policy space, we often cite to, early 2000 Iraq and so on and so forth.
Yeah.
Relative to then, when was the gloss kind of building up, if
Yeah.
you will, and is what we're seeing today kind of in specific areas or of a certain character?
Yeah, fair enough. So if you go back to any major kind of development points, you would find some gloss in attorney general writings or congressional debates. It's not going to be a new phenomenon. But are there turning points where it becomes more prominent? Yeah. And I would say, if I have to pick a time, and I've been asked this before, after the Spanish-American War, for all sorts of reasons, the executive branch and multiple administrations, two parties, both doing this, which is to assert more unilateral authority. And their lawyers, it was the solicitor of the State Department at first, eventually becomes OLC. It's not just OLC, by the way. They're different predecessors doing the same exact thing. They're international lawyers doing constitutional law, by the way, in the State Department, making these arguments in the early 1900s to justify lots of these different things. And then they start talking about what the prior practice looks like and maybe overgeneralizing from it. And it's not coincidental. The United States is on its way to becoming a world power by that point. After the Spanish-American War, its military is much more powerful. Its interactions around the world are much more extensive. And I will say the public, and to some extent Congress, expects robust executive authority as the United States is becoming a world power. Maybe we shouldn't have, et cetera, but they do. And the presidents then have lawyers' teams basically rationalizing that, I would say by the early 1980s, if I wanted to pick a time. It's not entirely a new style of argument, but it is much more actively trying to cite and accumulate. And they start publishing, the State Department starts publishing these lists. Every time we've ever used force, 1803 against that pirate island, 1805, they start collecting these long lists. Every time we've ever terminated a treaty, well, let's not worry about the 19th century, but in 1901, we did it on our own. They start making lists, and the practice then accumulates. So that's a big turning point, but not from 2010 or anything like that. You can take much of the 20th century. Looks very much like that, way before OLC was even in existence. Yeah. Okay, please.
Sorry, is it okay
Sure.
if I ask you a question?
Yeah.
You touched on this briefly in one of your previous answers, but I wanted to hear a little bit more about how political partisanship plays into your assessment of historical gloss.
Yes.
Do you try to look at multiple examples from both parties, or
exactly.
how does that play in?
Yes. So when we talk about glossing these kind of uncertain or open-ended provisions of the Constitution, I argue in the book that we should give much more weight to things that are long-standing and bipartisan. Why? If it's just one party pushing it, it's not likely to be stable because the other party's not likely to support it when they get back into power. But if we find both parties asserting it over changes and over multiple administrations, much more likely to have a kind of a stable practice. And if you don't find the other branch actively kind of fighting it, I don't actually use the word acquiescence that much in the book because I think it's too fraught, then you're likely to have a stable practice. But we know lots of things that might be more opportunistic, that one party might try to push through, and I don't think we should give that much weight. So I think this is better, by the way, than a lot of Supreme Court decision-making, where all of a sudden, if one president managed to get a bunch of appointments, our constitutional law lurches in an entirely new direction. That is not the way that gloss works. Gloss is a much more accretive kind of process that crosses politics over a pretty good stretch of time. I actually think that looks pretty good compared to a lot of our constitutional changes, and at least reduces some of the partisanship issues that we obviously have to deal with in the regular legislative process most of the time. How am I doing? I'm probably out of time.
Great. So 2 quick announcements before we wrap up the indoor portion. First, we're going to have another constitutional conversation next Thursday, same time and place. Stephanie Barclay of Georgetown is going to talk about strict scrutiny, give a talk in defense of strict scrutiny against a sort of more tradition-based approach. So that should be an interesting counterpoint. We also will continue this outdoors. As I mentioned earlier, go down the stairs and out to Cooley Courtyard, where we'll have a chance to continue the conversation and hopefully get some book signings. So thanks so much. Please join me in thanking Kurt.
Thank you. Thank you. Thanks.